Uh, Today, the topic that we are going to discuss is the most important topic for all the business owners. One who starts a business and builds the brand and happen to see that their brand is being copied. Suddenly, he finds out that someone uses the similar name or the designs. So there is always the doubt in the mind of an entrepreneur. How do we proceed about it? Like, should I take a legal action or something? So when a entrepreneur or a business owner finds out that his brand is copied, he makes two grave mistakes immediately. That is, one is that panic. The next one is ignoring that issue. So this is what we have seen in our experience. Like we have handled about like 25,000 trademarks as of now, and we have 17 plus years of experience. These two mistakes we always see during the if they panic, either they fail to take an immediate legal action, and they may face when they don't have the right legal rights, and then they take a legal action, it won't stand in the court, and they end up facing a legal action by the opposite party. The second one is the ignoring the copying of their brand or the infringements. What happens now is if a person who ignores the copy of the brands, and he ends up losing his entire brand rights over a period of time. There is something called in law which is called an acquiescence. Acquiescence is something that other person is copying your brand, but you let him, not taking any legal action, and over a period of time he brings his brand value, or he captures a market, and you end up losing the business. So both panic and ignore is what the business owners cannot afford to do. So how do we understand what to proceed? So by the end of the session, you will be able to assess in 5 minutes whether should I take a legal action or should I stay silent for some times, or it is not actually someone is copying my brand. So there is 3-point checklist we always suggest the client to see whenever someone copies a brand, whether the brand copy is similar, do they really have the rights, or the delay, how cost it is going to be. So next thing is the first thing we will say, okay, when it comes to someone copying the brand, does the brand looks the same? That's the question in mind, whether the brands are similar. It's not all the brands are similar. There are certain criterias we are going to look at. 3 tests we are going to do. This is a 3 test the court is used to do, whether to find out the similarity of the brands, or even a business owner to take any actions before that. So, but before that, we need to understand one important thing, that there is a difference between copied brands and counterfeit brands. The copied brands are having a similar name, similar look, and similar feel. But whereas the counterfeit products is the exact replica of your product. We don't have to do any analysis. We just have to get into take a legal actions against the parties who copies their brand. So these are the examples where you can see that the Adidas is similarly someone a similar name, no changes. It's an exact replica of your product. That's a counterfeit. But someone makes certain changes. It's not that identical. We look more into that. So what is that? So as I said, there is a trinity of similarity of the 3 types of the similarity test. One is the visual, the second is the phonetic, the third is the conceptual. The visual similarity is something the logo, color, style, layout all look similar. Phonetic is the brand sounds the same. The conceptual is the name of the brands looks different, but if you see the concept, they adopt the same elements which is in the other products. Let's zoom into that more on this. These are the brand looks similar. You see, lays and legs may sound similar, but it is almost on the border of counterfeit, where the other person has copied. And the same thing, Dettol and Devtol, or Purell or Purewell. These are the example. The other, but the copycats thinks that they are smart enough to add certain words, like they added a V or they added a G or something. So they made a lot of changes, but that's not true. That's not how court looks at. They see this similarly. So whenever a business owner finds out they have the brand name which is as similar as like their product, even the names sounds different, but the entire product layout and look are similar, they have to take an immediate action. The second is the phonetic similarity. The phonetic similarity is when the spelling might be different, but the pronunciation, the sound is the same. For example, look at the examples here. These look almost different, but it sounds the same. Calpol or Glucovita or Glucovita, these sound similar. The consumers doesn't see the product, but the most the consumer hears the name, they may get confused. They may think that that is another product launched by the same company, or maybe with a different design or something. So this is the second thing, that the phonetic similarity as a test that the court will say that okay, both the products looks different, but it sounds the same. So that is another thing the entrepreneur should look into when they have to go for a legal actions. Then finally, the conceptual similarity. Here, both the names completely different, not even similar like Glucovita or the Calpol, what we saw earlier. There is Domestos or Powerforce. You see that the brand names are entirely different. Then the other brand is Magnum and Fairy. Then another example is Nutel or Cremosa. The brand names are entirely different, but overall they adopted the same design of the product, the layout, get up, everything is similar. This is called a conceptual similarity. The other person might be thinking that I'm selling a different product, different brand. Their brand is Magnum. By my products is Fairy. But the truth is, they adopted the similar conceptual similarity. So whenever a business owner comes across certain kind of, they still have the right to take certain kinds of infringements or copying the brand names or the overall layout. So this is something that everyone to understand before knowing that okay, whether the brand names are entirely similar, or the look and feel is the same, or it's phonetically same. Once they have it, they think like okay, I have the other brand looks as similar as mine and I should go to court. But that's where we stop the client, where okay, this is before going to the court, there are certain checklists they have to undergo. Do they really have the legal rights to proceed? As we see, not all rights are equal. So we know that the trademark has to be registered. It is not mandatory, but it is recommended that all the brands gets registered. Only the registered trademarks has the full statutory protections. So they can sue for infringements, they can claim damages if someone copies their brand. Whereas the unregistered trademarks, if someone has a brand name and he sees his brand is being copied, but unfortunately he failed to register the trademark, it doesn't mean that unregistered trademarks cannot approach the court for legal remedy. They still can, but they cannot get a complete protection. What they can file is called a passing off. Passing off, where they have to prove that the other party intentionally copied their name and they are misrepresenting, or they are trying to pass off their goods as of their own products. So here, the person who files a case has to prove the actual damage. He can't just say that he's copying my registered trademark or the name is similar, whereas just because he's selling the product in the market, I am facing an actual damage. This is little bit hard to prove in cases of unregistered trademarks. In case of no registration and the brand is also not used in prior, this happens in sometimes where the brand owners they see some products selling online or sold in the market and they wanted to take a legal action. But end of the day, we find out that they don't have the trademark registration and they are not the first one to use the trademark. In both cases, it is pointless if they approach the court. Either they should have the registration and they should also have the prior use. These are the criteria they have to check. Even there are even say some people have registered trademarks, but they might be using subsequently than the other party. For example, we see certain instances where a client approaches and says, "Sir, I want to file a case against this guy copying my trademark." When we inquire, they say that we have started using the trademark from 2018 or 16 or something. But only when we investigate further, we come to understand that the other party, the person who is pointed copying his brand, is using few years earlier, say in from 2010, the other party is using. In this scenario, even he has a registered trademark, even the client has a registered trademark, they cannot take a legal actions against a prior owner. So all these needs to be considered before proceeding taking legal actions against the other party. So the registered is something where a brand is registered, they have the nationwide protection, they can file an infringement, they can claim statutory damages, as I said. Whereas the unregistered trademarks is something, the rights are limited, where they can only file a passing of, and they have to prove that they created a certain goodwill, they have the strong reputation in the market, and they should also prove that other party has intentionally copied their trademark. Only then they have to prove they can claim damages. And one more thing, the most important thing, if you are a registered trademark, you get to protect your brand name even before the customs enforcement support. There are certain clients who have a registered brands, and they found out uh, the other party has been importing from China, the other market, and we filed a complaint before an customs enforcement. So these products stopped at the moment they enter into the Indian market, where Indian borders. So the registered trademarks has so many advantages. So one that right, a business owner cannot afford to ignore. Then there is another thing, apart from the registered trademarks, prior use is also important. It's not you first register the trademark, you must be the person use the brand first in the market. So you should not be the subsequent adopter. So the person who used the brand for a long time and he built a goodwill and reputation, and he finds out a copycat appears in the market and copies the trademark, then he can go ahead and file a case against them. So finally, the question comes: should I take a legal actions or not? This is something where the client, okay, this may to maybe they copy today, they may not, they might be stopping in the future, or they may think that should I spend that much money to stop them or something. What happens is, when someone sees the other party copy their brand and they fail to take any proper legal action, court considered that as an acquiescence. So which is like so when we heard about the delayed justice denied justice. Similarly, court points out to the commercial unit is saying that if you delayed your request and your request is denied, because there's a particular section in Trademark Act which clearly says that a brand owner intentionally or omissions or fails to take an immediate legal actions against the other party who known to be copying his brand is considered to be acquired the other party's use. So we have seen so many cases where the other party, the person who copies the brand, claim to be copied the brand, comes up with a defense saying that there is a delay and latches on the other part. So this is where the loser right to object. Second thing is, as long as you leave the other person to copy your brand gets diluted. So customers starts to begin associating their brand name. Maybe they're thinking that we see lots of brands in the market, the same name sold by two different parties. Automatically that dilutes their brand value or also dilutes their market share. So there is always a first mover enforcement. You have a brand and you created certain reputation and you have penetrated the market, you hold certain share, the copycat started to spread and started to sell a similar name of products in the market. It's very important to take an immediate legal actions. So the court will see who acted fast and how soon they file this legal actions against the other parties. So this is what we wanted everyone to take a key takeaways for every business owners. The first thing, they should understand whether both the trademark are similar. We need to get into this in detail to see either both the brands look similar, visually, phonetically, or conceptually, and do they have the rights to proceed and take legal actions against the other party. What happens if they delayed what is the legal risk or a business risk associated with that. So here, the end of the sessions, you know that the three similarity tests that one should understand is visual and phonetic and conceptual. The person copying your brand might be looking visually similar or phonetically similar, or as we saw that it could be conceptual. And always register your trademark. It comes out very handy when, as and when you have to take some certain legal actions. The first thing any lawyer going to see is whether you have registered the trademark. Then the second thing they will see, the prior use in your mark, how long you have been using the mark, using the product in the market. Here we wanted to add few points to the clients. We see a lot of cases where the client says they are using trademark from 2005 or 2010, and they came across another party copying that trademark maybe a few years earlier, a few years before, like 2020 or 21. They wanted to file a case. When we ask for the prior use documents, like they have to provide certain evidences to show that they are using the brand for these 20 to 25 years. The documents they have to provide is the invoice bills, purchase bills, advertisements, promotional materials, and the turnover of their business and marketing expenses. And these are certified by an auditor. These are the main documents. But what we normally see when a business owner end up saying that, yes, we have been using the trademark for the past 20 years, but we don't have any sufficient proofs for that. This will not stand well in the court. The court sees the evidence. So if there is a startup listening to this, or any business owner, always keep certain number of invoices, keep a track of the user documents as a separate file, the actions that you did to improve the brand name, or the advertise the brand name or promote the brand name, the invoice bills, purchase bills in the name of the brand. Keep those as a evidence of record, which will come in handy if you find out someone is copying your name. The second thing is registrations. That is all, as I said, you have to register the trademark. It is non-negotiable. And when it comes to registration, we also see the gaps. It's not just a trademark registration. As we see in the conceptual similarity, the brands are different, but the artistic work is the same. The artistic work's protected under trademark as well as under copyright. So you also see a copyright registration. When it comes to trademark registration, don't just register a name alone or just as a logo alone. Register a word mark, register the device mark, and how the entire package looks like. So, and then also protect the copyright registration. This is what we call a 360-degree protection. So when you cover all those ends, you have a proper IP portfolio around your brand name. So finally, never delay taking a legal action. There is another mistake we see entrepreneurs do. When someone copies their brand, they delay taking a legal action, or they immediately step into that action and send a legal notice. But sending a legal notice is just initiating an action. That's when the clock ticks. So you send a legal notice, the other party denies it or fails to respond, and you stay calm over a period of 1 or 2 years. That's when, then after 2 years, you see the other person has expanded his market and he's also having a considerable market share. Now you want to take a legal actions against them? No. He'll come and say to the court that this person knows I'm using the same name or the similar name for the past 2 to 3 years, and he failed to take any legal actions. This actually backfires the entrepreneur's case. So whenever you see someone take a legal action, if they denies or refuses to withdraw the use, immediately proceed for a legal action. Again, the question in mind of lots of entrepreneurs we see often, how many years this will take. We know the court takes time, several years, but that was true few years before, maybe 5 6 years before. Now we have something called an IP division. Every high court has formulated an IP division in high court level or even district court level to hear the matters with respect to IP infringement cases. They have a time frame to dispose the cases. They have like 6 to 12 months of time. They have to hear the matter. In 12 to 18 months, the matter gets disposed. And the courts awards, there is a history of cases the court awarded damages in crores to the other party. They even award damages for litigation costs, 10 to 15 lakhs, 20 lakhs. They award litigation costs for the money the entrepreneur spend approaching the court. So the time has changed, the law has changed. So it's high time a business owner, when feel confident enough to take legal actions, or ensure all the efforts are taken to protect their brand name. Applying a brand name, registering a brand name is not the end of the road. Enforcing a brand rights is what it matters. Hope this session is helpful. I'm open to questions. Thank you.